Dear students, I welcome you to yet another lecture on corporate law. The subject of today's lecture shall be the Memorandum of Association. We shall also discuss the contents of the Memorandum of Association. We shall discuss the doctrine of constructive notice and the doctrine of indoor management. The Memorandum of Association is a document of fundamental importance in relation to the proposed company. It contains the basic conditions upon which the company is allowed to be incorporated. It is also called the Constitution or the Charter of the company. It lays down the area of operation of the company. It also regulates the external affairs of the company vis-à-vis outsiders. Its purpose is to enable the shareholders and those who deal with the company to know what its scope of authority is. Dear students, we shall now discuss the importance of the Memorandum of Association. The Memorandum of Association is the most essential document for the company due to these reasons. The first is unalterable charter. The provisions of the Memorandum of Association cannot ordinarily be changed. They can only be changed by adopting a special resolution passed by 75% majority of shareholders. Second is the basis of incorporation. Memorandum of Association is the basis of incorporation, and a company cannot be registered without filing this document. It is the basis of incorporation of the company. Thirdly, it also helps us to determine the working limits of the company. It sets out the limits of the company's activities. Any activity outside the scope of the memorandum will be ultra vires and void. If an act is ultra vires, the company, even the entire body of the members, cannot validate it and bind the company. This is known as the doctrine of ultra vires. Fourthly, to determine the relationship between the company and others. The Memorandum of Association enables outsiders to know whether the company is authorized to enter into a particular transaction. Fifthly, it informs the name, the address, the objects, and the capital of the company. In its external appearance, every outsider can easily know some important and common points of information about the company through the Memorandum of Association. Now, dear students, we come to the definition of Memorandum of Association as provided in the Companies Act. According to Section 2, Clause 28 of the Companies Act, memorandum means the Memorandum of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this Act. This definition of the Act does not throw any light on the scope, the use, and the importance of the Memorandum of Association in a company. We shall therefore examine some better definitions given by judges. Lord Keynes, in the leading case of Ashbury Railway Carriage Company versus Ritchie, observed that, and I quote, "The Memorandum of Association of a company is its charter and defines the limitations of the powers of the company," unquote. The memorandum contains the fundamental conditions upon which alone the company is allowed to be incorporated. Dear students, we shall now discuss the purpose of the memorandum. The purpose of the Memorandum of Association is twofold. Number one, the prospective shareholders shall know the field in which or the purpose for which their money is going to be used by the company and what risks they are undertaking in making the investment. The outsiders dealing with the company shall know with certainty as to what the objects of the company are and as to whether the contractual relationship into which they contemplate to enter with the company is within the objects of the company. Dear students, we shall now discuss the contents of the Memorandum of Association. According to the Companies Act, the Memorandum of Association must contain these clauses. Number one, the name clause. The name of the company should be stated in this clause. A company is free to select any name it likes, but the name should not be identical or similar to that of an already registered company. Also, the name should not be undesirable in the opinion of the central government. Another restriction is that the name should not be such that its use by the company will constitute an offence under any law. a company shall not be registered with a name which contains any word or expression which is likely to give the impression that the company is in any way connected with or having the patronage of the central government or the state government or any local authority, corporation or body constituted by the central government or any state government under any law. It should also not use words like the king, queen, emperor, government bodies and the names of the world bodies like the UNO, the WHO, World Bank, etc. If it is a public limited company, the name of the company should end with the word limited, and if it is a private limited company, the name should end with the words private limited. A company may, by passing a special resolution, alter its name with the approval of the central government in writing. However, no such approval shall be necessary where the only change in the name of the company is the deletion or the addition of the word private, consequent upon the conversion of any one class of companies to another class in accordance with the provisions of the Companies Act. The intimation of the name change should be given to the registrar, who will issue a fresh certificate of incorporation. Dear students, the second clause in the Memorandum of Association is the Situation Clause. In this clause, the name of the state where the company's registered office is located should be mentioned. Registered office means a place where the common seal, the statutory books, etc. of the company are kept. The company should intimate the location of the registered office to the registrar within 30 days from the date of incorporation or commencement of business. The alteration of the memorandum relating to change in the place of the registered office from one state to another state shall not have any effect unless it is approved by the central government on an application in such form and manner as may be prescribed. Dear students, we now come to the most important clause of the Memorandum of Association, which is the Objects Clause. The most important clause of the Memorandum of Association is the Objects Clause because it lays down the purpose for which the company is formed and the kind of activities or business it intends to carry on. The importance of the Object Clause lies in the fact that it determines the purpose and the capacity of the company besides its sphere of activities. Although express powers are necessary, a company may do anything which is incidental to and consequential upon the powers specified in the Objects Clause, and such acts shall not be ultra vires. The company should confine its activities within its stated objects and not beyond the objects stated in the Objects Clause. Dear students, we now come to the fourth clause, which is the liability clause. This clause states the liability of the members of the company. The liability may be limited by shares or by guarantee. This clause may be omitted in case of a company with unlimited liability. Dear students, the fifth clause of the Memorandum of Association is the capital clause. This clause mentions the maximum amount of capital that can be raised by the company. The division of capital into shares is also mentioned in this clause. Lastly, dear students, the subscription clause of the Memorandum of Association contains the names and addresses of the first subscribers to the Memorandum of Association. The subscribers to the Memorandum of Association must take at least one share. The minimum number of members is 2 in case of a private company and 7 in case of a public company. Dear students, we shall now discuss the doctrine of constructive notice. The memorandum and articles on registration assume the character of public documents. The office of the registrar is a public office and the documents registered there are open and accessible to the public at large. Therefore, everyone dealing with the company is deemed to have notice of the contents of the memorandum and the articles of association. This is known as the doctrine of constructive notice. Under this, every person dealing with or proposing to enter into a contract with the company is deemed to have constructive notice of the contents of its Memorandum of Association and Articles of Association. Whether he actually reads them or not, it is presumed that he has read these documents and has ascertained the exact powers of the company to enter into the contract, the extent to which these powers have been delegated to the directors, and the limitations to such powers. he is presumed not only to have read them but to have understood them properly. Consequently, if a person enters into a contract which is beyond the memorandum of association or beyond the authority of the directors conferred by the articles, then the contract becomes invalid and he cannot enforce it, notwithstanding the fact that he acted in good faith and the money was applied for the purposes of the company. In Kotla Venkataswamy versus Chinta Ramamurthy, the Articles of Association of the company required that all the documents should be signed by the managing director, the secretary and the working director on behalf of the company. A deed of mortgage was signed by the secretary and the working director only. The court held that the deed was invalid. The learned judge observed that the mortgagee should have consulted the articles before the deed was executed. Therefore, even though the mortgagee may have acted in good faith and the money borrowed applied for the purpose of the company, the mortgage was not valid. Dear students, we shall now discuss the doctrine of indoor management. The doctrine of indoor management has been laid down in various judicial decisions. The hardships caused to outsiders dealing with the company by a rule of constructive notice has been sought to be mitigated under the doctrine of indoor management. It affords some protection to the outsider against the company. According to this doctrine, after satisfying themselves that the proposed transaction is within the scope of the memorandum and the articles, persons dealing with the company are not bound to inquire whether the internal proceedings were properly followed or not. They are entitled to assume that the internal proceedings relating to the contract are in accordance with the memorandum and the articles. As per the doctrine of constructive notice, an outsider entering into a contract with the company is presumed to have knowledge of the contents of the memorandum and articles. But there is no obligation on him to go beyond that and to inquire whether the internal proceedings mandated by these documents have been adhered to by the company. They need not investigate whether the necessary meeting was convened and held properly or whether the necessary resolution was passed in accordance with the Memorandum of Association and the Articles of Association. They are entitled to take it for granted that the company had gone through all these proceedings in a proper manner. This is known as the doctrine of indoor management. Whereas the doctrine of constructive notice protects the company against outsiders, the doctrine of indoor management protects the outsiders against the actions of the company. This doctrine is also a possible safeguard against the possibility of abusing the doctrine of constructive notice. The rule is based upon obvious reasons of convenience in business relations. Firstly, the memorandum and articles of association are public documents open to public inspection. Hence, an outsider is presumed to know the constitution of the company, but not what may or may not have taken place within the doors that are closed to him. The wheels of commerce would not go round smoothly if persons dealing with the company were compelled to investigate thoroughly the internal machinery of a company to see if something is not wrong. People in business would be reticent in dealing with such companies. Dear students, we now come to the origin of the doctrine of indoor management. This doctrine, the doctrine of indoor management, was first laid down by Lord Hatherlane in the landmark case of Royal British Bank versus Turkant. The directors of the bank had issued a bond to Turkant. Under the articles, the company was empowered to issue such bonds provided it was authorized by a resolution of the company in the general meeting. In this case, no such resolution had been passed. It was held that Turkant could recover the amount of bond from the company on the ground that he was entitled to assume that the necessary resolution had been passed by the company. Dear students, we shall now discuss the exceptions to the doctrine of indoor management. The exceptions to the doctrine of indoor management are: number one, knowledge of irregularity. When a person dealing with a company has actual notice of the irregularity as regards the internal management, he cannot claim the benefit under the rule of indoor management. He may in some cases be himself a part of the internal procedure. The rule is based on common sense, and any other rule would encourage ignorance, condone dereliction of duty and lead to an unjust result. In T.R. Pratt Bombay Limited versus E.D. Sassoon and Company Limited, Company A, on a mortgage of its assets, lent money to Company B. The procedure laid down in the articles for such transactions was not complied with. The directors of the two companies were the same. Hence, it was held that the lender had notice of the irregularity and the mortgage was not binding. Similarly, in Howard versus Patent Ivory Manufacturing Company, the directors issued debentures to themselves. The extent to which they were lending money to the company required the assent of the general meeting, which they had not obtained. They could not defend the issue of the debentures to themselves because they should have known that the extent to which they were lending money to the company required the assent of the general meeting, which they had not obtained. Likewise, in Morris versus Canson, a director could not defend an allotment of shares to himself as he had participated in the meeting which made the allotment. His appointment as a director also fell through because none of the directors who had appointed him was validly in office. The second exception to the doctrine of indoor management is suspicion of irregularity. Where the circumstances surrounding the contract are suspicious and therefore invite inquiry, the protection of the Turkins rule is not available. Suspicion should arise, for example, from the fact that an officer is purporting to act in a matter which is apparently outside the scope of his authority. Where, for example, as in the case of Anand Bihari Lal versus Deenshaw and Company, the plaintiff accepted a transfer of a company's property from its accountant. The transfer was held to be void. In the absence of a power of attorney, the plaintiff could not have supposed that the accountant had the authority to transfer the property of the company. The next exception is forgery. Where a person relies upon a document that turns out to be forged, the rule in Turkin's case does not apply, since forgery cannot be validated under any circumstances whatsoever. A company can never be held bound for forgeries committed by its officers. The leading case on the point is Rubin versus Great Fingal Consolidated Company. In this case, the secretary of a company issued a share certificate under the company's seal with his own signature and the signature of a director which was forged by him. It was held that the share certificate was not binding on the company. The person who gave money on the strength of this certificate was not entitled to be registered as the holder of shares. The fourth exception to the doctrine of indoor management is acts outside the scope of apparent authority. If an officer of the company enters into a contract with a third party and if the act of the officer is beyond the scope of his authority, the company is not bound. In Credit Bank Castle versus Schenkers Limited, a branch manager of the company drew and endorsed bills of exchange on behalf of the company in favor of a payee to whom he was personally indebted. He had no authority from the company to do so. It was held that the company was not bound. But if an officer of a company acts fraudulently under his ostensible authority on behalf of the company is liable for his fraudulent act. In Freeman and Lockyer versus Buckhurst Park Properties, the claimants were architects. They entered into a contract with 1K relating to the development of Buckhurst Park, a property in London. Mr. K and others had formed the defendant company with a view to developing the property. Mr. K was a director of the defendant company, the articles of association of which allowed the company to appoint one of its 4 directors to the position of the managing director, who would thereby have the authority to enter into contracts on behalf of the company. Mr. K was never appointed the managing director, although he successfully led the claimants to believe that he was appointed as a managing director. Subsequently, it became apparent that the development would come to fruition. The claimants commenced proceedings for their outstanding fees. As K's whereabouts were unknown, the claimants were required to bring a claim against the company on the basis that K had the authority to act on behalf of the company. The court held that although K had no actual authority, whether express or implied, to act on behalf of the company because he had acted as if he were and had been allowed to do so by the other directors, he thereby had apparent or ostensible authority to act on behalf of the company. As the company had acquiesced in his acting as if he were its managing director, he was stopped from disputing that he did not have the authority to enter into the contract on that basis, and the company was therefore required to pay the claimants their fee. Lord Justice Diplock stated, and I quote, "An apparent or ostensible authority is a legal relationship between the principal and the contractor created by a representation made by the principal to the contractor intended to be and in fact acted upon by the contractor, that the agent has the authority to enter on behalf of the principal into a contract of a kind within the scope of the apparent authority so as to render the principal liable to perform any obligations imposed upon him by such contract. The representation which creates apparent authority may take a variety of forms, of which the commonest is representation by conduct, that is, by permitting the agent to act in some way in the conduct of the principal's business with other persons. By so doing, the principal represents to anyone who becomes aware that the agent is so acting that the agent has authority to enter on behalf of the principal into contracts with other persons of the kind which an agent so acting in the conduct of his principal's business has actual authority to enter into, unquote. Dear students, this is all with regard to today's lecture. In today's lecture, we tried to understand what is meant by the Memorandum of Association. We also tried to understand the contents of the Memorandum of Association. We tried then to understand the doctrine of constructive notice and the doctrine of indoor management. We also discussed the exceptions to the doctrine of indoor management. Dear students, I hope that you have understood the contents of today's lecture fully. Stay blessed.